Yeah?
My name is Bashir. Lord, I do apologize that I did not know because I...
No, for rulings you don't have to rule. This is for the petitions. So you're properly before the court. Yes.
My name is Onati. I do hold brief
Involving a matter of general public importance. We have looked at the history of the matter from the High Court to the Court of Appeal and to this court, and to the denial of leave to appeal. We have looked at the law as we understand it, the submissions as you have put before us, the cases of Hermanus Philippus Stein, Malcolm Bell versus Daniel Moi, Peter Ngoge versus Francis Ole Kaparo, and looking at the principle in the Hermanus case as well as the Awendo case, Narrow County Council versus Livingston Olentutu, as well as Isaac Tokanangan Tokibebia and Isaiah Teurinto Lintari. We have come to the conclusion that this is a fit case for the leave to appeal to have been granted, and therefore the orders of the court are as follows. The motion dated 2nd April 2015 is allowed. The decision of the Court of Appeal declining leave to appeal is set aside. The matter is certified as one involving a matter of great public importance, which we have set out as being the only issue shall address the court on is whether the land subject matter of this suit was initially trust land, a public beach, or a mangrove forest protected under the Forest Act, and if it was trust land or public land, was it properly, regularly, and legally allocated to Honorable Kasim Mwamzandi and later to Party Limited, the applicant hearing. That is the only issue which you shall address the court on. The stay order granted by Justice Ibrahim on the 10th of April 2015 shall subsist until the appeal is heard. Costs of the application shall be in the course. This is the decision of Mwilu, Deputy Chief Justice, Judge Ibrahim, Judge Wanjala, Judge Njoki Ndongo, and myself. Affidavits, your submissions, and we have distilled two issues for determination: whether this court has jurisdiction to deal with the matter, whether the orders of stay can issue on jurisdiction. We have considered your submissions, and we have come to the conclusion that was filed on the 25th of January 2019. At page 2, we have given a background to the proceedings before the High Court, including the initial appeal, which ended in remittance of the matter back to the High Court at Embu. We have then looked at the subsequent hearing by Lady Justice Gitari at page 3. We have then looked at the decision of the Court of Appeal of 20th December 2018. At paragraph 8 on page 4, we have summarized the grounds of appeal, which I don't need to do in substantial. We have then at page 6 looked at the submissions by the petitioner, which we have summarized into the following areas: burden of proof in electoral matters, fair trial and hearing, alleged nullity of the proceedings before the High Court, bias and discrimination against the petitioner. We have at page 9 then looked at the first and second respondents' responses on the question of burden of proof, infringement of the petitioner's right to fair hearing and trial, the nullity of the High Court proceedings, and reliance on the Lemanken Aramat versus Harun Meitami Lempaka decision, and then the question of costs. As regards submissions by the third and fourth respondents, we have looked at the question of jurisdiction, reliance on the case of Suleiman Mamlole Waraka, Nazra Ibrahim Ibren, Daniel Kimani Njehia. We have looked at their submissions on the nullity of the High Court's proceedings, the alleged infringement of the petitioner's right to fair trial and hearing, and burden of proof as well as costs. What are the issues for determination? Issue number A, whether the petitioner has properly invoked this court's jurisdiction under Article 163(4)(a) of the Constitution. Issue number 2, whether the proceedings before the High Court were nullity, and if so, what are the consequences thereof. Issue number C, whether the petitioner's right to fair hearing and trial was violated by the respective findings of the trial court and the Court of Appeal. Issue number D, which party bore the burden of proof. Issue number E, whether the Court of Appeal properly evaluated the evidence before it. Issue number F, whether the trial court was biased against the petitioner. Issue number G, what relief should issue. And issue number H, who should bear the costs of these proceedings. On jurisdiction, we concluded, having looked at the case of Suleiman Mamluele Waraka, the case of Daniel Kimani Njehia, that looking at the petition, although the petitioner relied on Rule 9 at the body of the Rule 9 and 33 of the Supreme Court rules, we distinguished the Waraka case because in the body of the petition and in submissions, it was obvious to us that Articles 27, Articles 50, Articles 81, Articles 86, and Articles 87 were in contest before us. Specifically, we found that when the issue whether the proceedings before the High Court were nullity under Articles 87(1) and 105 of the Constitution, that matter then places the dispute squarely before the Supreme Court for interpretation of those articles that I've mentioned. The more fundamental question that came in this appeal is whether the proceedings before the High Court were nullity, and if so, what are the consequences? We have looked at the ruling delivered by Justice Gitari in the hearing, and her argument was that the proceedings were stayed once the matter went on appeal. We have, however, looked at our decision in Gatrao Peter Munya. We have looked at our decision specifically and particularly in Manken Aramat, which we have quoted at length. We have looked at the Elections Act and the Constitution, Articles 105(2). We have also looked at Hassan Ali Joho and Evans Odhiambo Kidero, and Article 87, Section 75 of the Elections Act, the case of Gerald Iha Toya versus Chiriba Daniel Chai, per Justice Korir, a pronouncement that we agreed with at page number 23. We also looked at the Court of Appeal decision in Charles Kamuren versus Chelagat Grace Kipchoim, which we've quoted at page 24. We have further looked at Justice Korir's decision in Samuel Kazungu Kambi and Nelly Ilongo and two others, which we agree with, and we've quoted at page 25. We have looked at Cornel Rasanga Amof versus William Odhiambo Duol and Benjamin Onguyo Andama versus Benjamin Andola Andanyi. And at paragraph 55 of the judgment, we have said that it seems to us that we need to give guidance to courts below on how they should deal with matters within the 6 months time frame as the edict of the Constitution and the Elections Act is. And we have proposed the following issues before I determine what our decision is. All applications by a respondent to an election petition, save in exceptional circumstances, should form part of the response to the petition. Similarly, a petitioner should as much as possible file any application arising from his petition, e.g. for scrutiny or recount, at the same time as the petition. B, unless for want of jurisdiction or in any other deserving circumstance, a trial court should exercise restraint in striking out a petition or a response where such an action is likely to summarily dispose of the matter. C, all applications for striking out an election petition for want of jurisdiction for any other reason must be made and determined within the constitutional and statutory timelines for the resolution of electoral disputes. In this regard, it is for the trial court to make and enforce such case management orders so as to meet this objective. Number D, appeals on intellectual applications other than for striking out in circumstances explained in B and C above should await the final determination of the whole petition before the trial court. In exceptional circumstances, that is E, an appellate court may dispose of an appeal arising from intellectual application filed and determined by the trial court while the substantive matter is still ongoing at the trial court. In doing so, the time frame question as above must always be borne in mind. At paragraph 44, we specifically faulted the Court of Appeal because in the first appeal, the Court of Appeal knew very well that the time frame under Article 105 had been exhausted, yet they referred the parties back to the High Court, well knowing that there was no possibility, humanly possible, for the matter to be determined at the High Court within the remaining period. Our view, therefore, is, sadly, the proceedings before the High Court were a nullity, and as such, we have no jurisdiction to determine any other issue which we have distilled above. We have then addressed the question of costs, and we have said we must sympathize with the petitioner, who without any fault of our own has been locked out of the seat of justice. We take the long time we note the long time the process has taken, the huge financial resources that have been spent by both parties, but in law, generally, whereas a successful party ought to be paid costs, where proceedings are declared a nullity, no party can claim success. And that is a decision we also borrowed from the Supreme Court of Jamaica, interestingly, good times, in Paul Chen Yang versus Ajax Investments Limited. And therefore, we order that each party will bear their costs at the High Court, at the Court of Appeal, and in this court. The final orders of the court, therefore, are as follows. The petition of appeal dated the 25th of January 2029 is hereby dismissed. Costs of the proceedings before the High Court, the Court of Appeal, and this court shall be borne by each party.